Good afternoon and welcome to today's webinar, Choosing the Right Non-Disclosure Agreement, presented by the Federal Laboratory Consortium for Technology Transfer. My name is Amy Thompson, the FLC's Director of Professional Development, and I will be your staff host today. All lines have been muted to ensure high-quality audio, and today's session is being recorded. If you have a question for the panelists, we encourage you to use the Q&A feature. If you have a technical question or a comment, please feel free to use the chat. I now have the pleasure of introducing you to today's distinguished speakers, Samantha Updegraff and James Kosiski. Samantha Updegraff is a senior IP patent counsel at Sandia National Laboratories. She has worked at Sandia for about 6 years. At Sandia, she primarily works on IP and tech transfer matters, including license agreements, CRADA and SPP agreements, non-disclosure agreements, memorandums of understanding, and any other tech transfer and IP matters. She also manages a patent portfolio. Prior to Sandia, she worked as a patent attorney at a local law firm in Albuquerque, New Mexico. Mr. Kosiski has been Supervisory Patent Counsel for Naval Undersea Warfare Center Division, Newport, since 2003. He has an extensive practice as a prosecuting patent attorney, as well as prosecuted over 500 patent applications to issuance as patents. He also has been actively involved with the federal intellectual property, legal, and technology transfer communities. In the past, he has served as chair of the Federal Laboratory Consortium's Legal Issues Committee. Please join me in welcoming Samantha and Jim. Samantha, take it away.
Thanks, Amy. Okay, you all, thank you for joining. We're going to talk about non-disclosure agreements today. Next slide. So a few of the items that we're going to talk about, we're going to just briefly touch on what an NDA is and when you need one, the typical restrictions that are in an NDA, marking requirements, and then Jim is going to talk about government and NDAs and different government agreements that look like NDAs. I'm going to talk about how you manage the information that you receive under the NDA, some potential pitfalls, some best practices, when you want to amend or extend the NDA, disclosure of the information that you receive under the NDA to third parties and different requirements for that, as well as what happens when you wrap up an NDA, when the NDA term expires or the period of protection expires. Next slide. So a non-disclosure agreement, it's a legally binding agreement. So it is a contract between two or more parties where at least one of those parties is going to receive proprietary or confidential information from the other party. And so the recipient of that information has certain obligations and restrictions for using that information that was given to it by the disclosing party. Next slide. So when do you need an NDA? These are some of the questions that we ask typically when we're in this situation. What is the risk to the company if the information is released? I often say, what if the information that we want to share is going to be put on the company's website? Will we be harmed by that? Do we not want that? Oftentimes we want to be able to control that information. Where did the information come from? Is it your company's information? Is it government information? Is it some other party's information? Is there third-party proprietary information that needs to be protected that you want to share? Is it some sort of new technology that you want to share that maybe you want to protect using the patent process? A lot of times when somebody just wants to engage another party to see if maybe there could be some sort of relationship, you don't need an NDA because you can keep those talks at a high level. But oftentimes if you're not prepared or not comfortable disclosing certain information to another party, then it's best just to go with an NDA so you know that that information is protected and you have a little bit more control over what they do with that information. Of course, if there's other sensitivities, export control sensitivities or government classification activities, those all need to be taken into account as well. Next slide. So some of the typical provisions in an NDA, oftentimes there'll be a purpose. So why are the parties exchanging information? Sometimes you want a narrow purpose, so you can only use that information for that narrow purpose. or sometimes you want a really broad purpose, like you want to explore a relatively broad relationship. Maybe the purpose is broad for business reasons. There's usually often a definition of proprietary information included, and this kind of says what you're going to disclose under the NDA. Are you going to disclose financial information? Are you going to disclose technical information? We don't like to receive software under an NDA, so we will oftentimes strike that from the definition of proprietary information because software is protected by copyrights. There's a bundle of rights that are protected under copyright that aren't necessarily disclosed in the NDA. So there are certain things that you can do when you're defining proprietary information to ensure that you're receiving or giving the information that you want. We oftentimes always have a marking clause. How is that information going to be marked? How are the recipients of that information going to know that it falls under the NDA and should be protected as proprietary? And then there's usually a clause with exceptions. If the information that you're receiving is already on the internet and in the public, then it shouldn't be protected under the NDA. It's already in the public domain. So you'll have an exception clause, mostly giving it the exceptions for proprietary information. And then there's almost always two separate time periods. So there's the term, and that's usually 1 to 3 years, can be 5 years. And that's just when you're going to have this relationship, have these discussions, have these exchanges. And then there's the period of protection. So after that term expires, how long do you have to protect that information after that? We usually try to do 5-year period of protection. So after that NDA ends, the recipient of proprietary information will protect it for an additional 5 years. And typically, by the time that 5 years is up, all the information has been overcome by events anyway, and it's no longer that, it's been published and it's no longer needed to be protected. Next slide. So there's lots of different restrictions that can be in an NDA. Like I said, there's limitations on use. So that can be pretty narrow depending on what the purpose is. Typically, it will say you can only use the information that's disclosed to you for the purpose. Usually, you have to have a need to know. So not only will your company sign the NDA, but only those within your company that need to know that information should be receiving that access to that information. Future work conducted by those seeing the information. So a lot of times, larger companies don't want the recipient of the information to take that information and use it in future work. That can be tricky because you can't necessarily erase what's in your mind. You've learned the information. So of course it's going to be there when you do your future work. So that can be a little tricky. A lot of people, or a lot of times companies don't want you making copies of the information, and they don't want you to modify it. So if there's something that you're receiving under the NDA, let's say that you want to put into a government proposal and you're going to need to modify it, you need to make sure that that other party understands that. And then reverse engineering is similar to modifications. If you're going to receive information and it has to do with some destructive testing you're doing on the company's tools or something, and the NDA says no reverse engineering, you might want to clarify with that company, well, wait a minute, we are actually going to do destructive testing and potentially reverse engineering, so we're not sure that we should have this limitation in the NDA. Next question, or next slide. Show markings. I mentioned this before. We always try to require markings on our information that's going to be disclosed under NDA. This is very important, especially if you work closely with the government, because the government has a series of different markings that they have, and so we're used to it. We're used to dealing with documents that have markings. If we receive a bunch of information and none of it is marked, it is very difficult for the recipient to understand what should be protected and how. And it can get very tricky, especially if you work for a company or the government that has a Freedom of Information Act requests. If something isn't marked, there's always a risk that it could be inadvertently shared under a FOIA request. We have quite a bit of turnover at these companies now, at Sandia included. If there's turnover and the people that are managing the NDA leave and the information's not marked, how are future employees going to understand how it's supposed to be protected? So this is can be very important. It can be very risky if the recipient of the information is going to take on the burden of identifying the disclosing parties' proprietary information. We always try to get the companies, the third parties, to mark their information proprietary rather than confidential. This is just because there's a government classification of confidential, and we don't want our employees to be confusing, business confidential for external third parties with the government classification of confidential. Next slide. So I'm going to hand this over to Jim. He's going to talk a lot about the different government policies and procedures for non-disclosure. Jim?
Samantha, we had one question for you. I often see the terms proprietary and confidential seemingly used interchangeably, especially in NDAs. Can you comment on whether proprietary conveys that such information should be secret, or is the term strictly directed to ownership?
So most NDAs, it's directed to confidential as well. So it depends on the definition of proprietary information or confidential information in the NDA. Oftentimes it will define what the information being marked as proprietary is, but we treat it as both. So anything that's marked proprietary information, we treat it as confidential sensitive information under the NDA.
Thank you.
Sure. Okay, Jim?
Okay, I'll go ahead and take over now. As the government activity, we really don't like non-disclosure agreements, and a lot of that is because most government employees can't sign non-disclosure agreements. They are delegated by the government in contract. Another reason for this is that the Department of the Navy and Department of Defense require an affirmative statutory authority for any agreement. That means that something has to be in the law for us to sign it, to be a real agreement. Because of all this, we need to have different strategies for dealing with NDAs. Next slide, please. Next slide, please. Okay, go back one slide. I might have missed something there. Okay, this slide is kind of an overview of the different strategies we use. Just in summary, I'll talk more to them later. There are procurement-related non-disclosure agreements. On these, we can stick the non-disclosure agreement to a contract. This can include software licenses. It can include various data rights licenses. The DFARS have rules for this. Okay, the next one is non-disclosures related to research and development agreements. Okay, this is the slide for procurement-related NDAs. These are associated with a commercial purpose. A contracting officer can accept these as part of the procurement. This is usually a commercial software license or some sort of end user agreement. Sometimes these are related to commercially developed hardware. And anyway, all the usual rules apply to this, but it's usually going to be the contracting officer who signs. Very often the contracting officer seeks legal approval, so I have to look at the agreement and check all the clauses. The Federal Acquisition Regulation FAR and the Defense Federal Acquisition Regulation Supplement DFARS, they do a pretty good job of dealing with this stuff. This is just, everything we buy, it's generally covered by the rules. Next slide. Okay, research and development NDAs. This is an agreement between, say, a DoD lab and an outside thing. I think some others out there use them. The DOE labs use them. I know NASA uses a Space Act agreement that's pretty similar. In any case, this is for collaborative research, and this really may be the best NDA option if you're doing collaborative research, or even in a slight case of sharing information with especially again, DoD lab because of our rules. The agreement provides terms for handling and marking the information and the information created through the agreement. All of Samantha's rules and everything she has said apply to this agreement as well as everything. Court opinions have generally held federal laboratories strictly to the terms of the agreement. As far as because it's a cooperative agreement, we need to be nice about what we're doing here. We can't cross a small business or our partner. Next slide. Okay, this is the really hard case. This is when we have an employee who's going on a site visit, or somebody said, hey, I'll let you see my computer program, but you need to sign this non-disclosure agreement first. The problem is most federal employees don't have the power to bind the government. And if they sign these agreements, they are signing their own personal liability. We really discourage employees at my lab from signing these things. So, very often they call me and say, hey, Jim, I can get this really great data if only I can sign. So we kind of look for a workaround. One thing is federal employees are subject to 18 U.S.C. 1905. That's a criminal statute. So the employee can go to jail for disclosing. That's kind of, I think, a pretty big deterrent. Very often, one of our strategies, probably the easiest strategy, is to have the employee sign a statement that he or she is aware of 18 U.S.C. 1905. This also has a statement excluding whistleblowers from non-disclosure. This is often enough. At least it gets the employee's name down on a piece of paper saying that they understand the importance of the information. I think that the outside party can do some other things like mark the data and take proper care with it and stuff like that. If more is needed, I think using a CRADA is probably the best tactic. Because it specifies all the marking, it specifies should the data be returned, what we're going to do with the data, how long the agreement lasts. It defines the proprietary information or whatever. Another one is that procurement related, it's fairly broad. So if software is going to be sent for evaluation, we can probably cover that under procurement related. Ultimately, the buck stops with the head of the organization, and I believe that the head of the organization could promise for the organization. I have never gone that far. I've usually found a different way to do things. Next slide. Okay, we make all these rules and we say we're not signing any non-disclosure agreements. However, we can produce non-disclosure agreements and request that outside entities sign them. I think that's kind of not really happy to do that, but it's mostly when we're trying to license an invention and we want to let the outside party have an early view into the invention disclosure, or an early view into the patent application. That's mostly where we've used it. Usually we would try to use a CRADA. Next slide. Okay, there are a lot of government agreements that look like NDAs, but they're really something else. There are government-to-government employee agreements. These are usually used when, say, one of our employees is serving on, say, a procurement source selection panel. Usually I treat those, if I see them, as, okay, the employee's supervisor is really ordering that employee not to disclose the information. And then if that employee discloses the information, then that'll be, disobeying orders. I think that's probably the best approach for that. It's really what'll happen. Okay, export agreements, control agreements. Those are, so like if we're buying equipment from Denmark, sometimes the equipment is covered by the Danish export control regime. And those look a whole lot like non-disclosure agreements, but then they have a whole separate deal to how do you sign those. And it's a different world. I'm not going to go into it here. Okay, another one is one government lab can enter into a memorandum of understanding with another government lab. The government can't really sue itself, but your command or your organization, its honor is on the line with the other government organization so that you don't disclose the information. Not really an NDA. And I think the next is for Samantha. So next slide.
Yes, hi. Thanks, Jim. I did want to mention that when Sandia does not sign non-disclosure agreements with any federal government agency, under the prime contract that Sandia has with DOE, we have an obligation to protect government information. And we do often have individuals, individual employees that come to Sandia for various meetings, tours. We do not require them to sign an NDA, but sometimes we will require them to sign an acknowledgement of the protections under 18 U.S.C. 1905. So that's pretty consistent with what Jim was talking about. Okay, so I'm going to talk a little bit about managing the proprietary information received under an NDA. This is the meat of the NDA, in my opinion. The first thing that's really important is those that are receiving proprietary information or sharing the proprietary information, they really should read the NDA, not just the legal counsel that's reviewing it. I've had a lot of people that I'm talking to about the NDA and they say, oh, I can't read it. I don't understand it. I say, well, you can read it, I promise. And if you have any questions about understanding it, you should ask, because you're under this legal obligation to protect this information. So you really should understand how you're going to manage this proprietary information that you're going to receive or share. It's very important to pay attention to the restrictions. Many of them we previously talked about. A lot of times there will be obligations when the NDA expires. So without notice, you may have to return the information you received under the NDA. You may have to stop using all the information that you received under the NDA right at the expiration. So if you don't kind of have that management plan in place and you don't understand what your obligations are, you might inadvertently breach the NDA because you continue to use the information when really you should have stopped, and maybe you still need to use the information. So that's something that you should pay attention to. Again, we talked about the purpose of the NDA. Many times, and I talked about this before, you have to prove that you destroyed the information that you received under the NDA, so you're going to have to remember to do that. We've had issues in the past where we have multiple non-disclosure agreements with the same company, and there are overlapping and conflicting terms of conditions, and we haven't properly managed which information we received under which NDA. So if you have multiple NDAs with multiple terms, you're going to have to keep track of what information you receive under which NDA, because that information is going to apply to that NDA, but other information that you receive from the same company might apply to a different NDA. So it can get very complicated very quickly. So it's very important to have a very robust management of this information that you're receiving. The period of protection, we always try to make it 5 years. We can protect it for longer, but the longer you protect, another party's information, the higher the risk that it could inadvertently get shared. There's a lot of companies that want a perpetual or indefinite protection. That can be very difficult to manage, especially 20 years down the line. They're really shifting that risk to the recipient of the proprietary information. So we push back on that pretty heavily. And then oftentimes, we're receiving proprietary information from a company that we have an NDA with, that we're incorporating into something that we need to share with somebody else. Well, you typically can't do that under an NDA unless you write specific exceptions. So oftentimes, if we're going to be sharing this information, mostly it's with the government customer, we will have that exception in the NDA that says, we are going to protect this NDA or this proprietary information. We're not going to share this proprietary information with any party except for the US government. And then we can usually narrow it to a specific customer for a specific project. But at least that gives the technical folks the ability to share that information that they need to with their customer. So just keep some of these things in mind when you're reviewing and drafting non-disclosure agreements. Next slide. So some potential problematic clauses. Governing law, especially with foreign jurisdictions. You know, we, of course, here at Sandia, we're in New Mexico, we're in California, and then we're a Delaware company. So we can accept any of those jurisdictions for governing law. We don't usually like to accept any other governing law. We can remain silent. So if somebody wants, you know, a different state or even different country, we often push back and say, well, let's just, you know, kick the can down the road and remain silent for now. There's many times they want warranties on different things. We don't like to warrant, we would rather represent, so we usually change that. Sandia and pretty much all the other, at least DOE laboratories, cannot indemnify. So if there's an indemnification clause, we'll remove it. A lot of times they'll try to make it retroactive for information that we've already received maybe months ago. This can be problematic. Binding arbitration clauses, you know, many federal laboratories aren't allowed to agree to binding arbitration without their government sponsor permission. And this is a big one. The results of any analysis of third-party proprietary information becomes a property of the third party. This conflicts, at least with Sandia's prime contract, that says that any technical data or technical information that's produced at Sandia is owned by the DOE. So those results of whatever analysis that Sandia is preparing from the information it received from the third party cannot be owned by that third party. So we've negotiated different things for that type of situation. Next slide. Next slide. Okay, some best practices. So negotiation strategies can be different depending on which party is disclosing and if both parties are disclosing. So for example, if Sandia is not disclosing information, but the third party is, that, you know, we're going to need to incorporate into a document that we're going to deliver to the government, then we might try to have a broader purpose. We might try to have no use restriction. So even after the term of the NDA ends or the period of protection ends, we want to be able to continue to use that information. Even if we're not sharing it, we can still use it for our internal R&D efforts. But if we're sharing our information, then perhaps we want a longer period of protection. Maybe we just want to limit it to a more narrow purpose. So it, you know, just depends. Some tips. Sorry, my dog is squeaking his dog toy. He opened the door and came in with his dog toy. Sorry about that. So it's important not to verbally agree to protect information, because then everything is vague and there's no record. It's best to have it down in writing so everybody understands what the obligations and restrictions are. So at Sandia, we only use non-disclosure agreements to exchange information. We cannot perform work under an NDA. We are strictly prohibited from our prime contract, so it can't even look like we're going to perform any work under the NDA. If we need to mention some work that we're doing that's related to the NDA, we will explicitly write the work that we're doing and which, you know, which agreement or how we're doing that work. So you can clearly see that we're only exchanging information under the NDA. We do not accept software under an NDA. We have gotten in trouble in the past because we received software under the NDA, and then we have to incorporate it into one of our software programs. And then the NDA expires, and we're still using the software. It's been incorporated into our software. We have to share it with our government customer. We have to make modifications to it. Those are all protected under copyright law. And so, you know, we're supposed to protect this software under this NDA, but it's been modified, it's been distributed, and it's going to continue being used well past the NDA. So we do not like to accept software under NDA. We will do a license for the software. Again, this relates to the work. We cannot commit to a collaboration or partnership under an NDA, really because the purpose is just exchanging information. And then I mentioned the software. Next slide. Sharing proprietary information with the government. I think I talked about most of this. We do try to get explicit written approval that we can share the third party's information with the government. Pretty much all of Sandia's work is for the government. So if we're going to be receiving proprietary information, it will likely go to some sort of government customer. A lot of times, not only will it need to go to a government customer, but we'll need to go to another government contractor. If that's the case, then we'll try to also write that in. So we'll say this proprietary information that Sandia is receiving can be shared with the U.S. government and U.S. government contractor for the specific purpose. It's just better if all parties have the same expectation on what's going to be done with the information, so you don't later get into relationship issues with what you've done with the information. Next slide. So there are different requirements in the NDA if you do need to share information with a third party. A lot of times you need to have it approved in writing and signed by a high level. This is if the third party believes this information is very valuable. It's their Coke recipe, and if this gets out, then they'll, they might not survive. Then you typically want to get some sort of approval in writing by a high level representative that you can share this information. If you think it's not as valuable, like maybe in a couple years they're planning on releasing it in a paper, or I think most people have a good sense, then maybe an email release that says, we need to share this with the DoD for this project. It's currently not permitted under the NDA. Please confirm in writing that this is permitted. So those are some different strategies for if you do need to share with a third party and it's not allowed under the NDA, you can always go back and ask for permission. Next slide. Amending the NDA. Typically, you amend an NDA only if you want to extend the term that you're going to be sharing under, potential change in legal or technical point of contact. Those are the two main reasons why you would amend the NDA. Pretty simple, but you really need a new NDA if the purpose is changing. If the original NDA has already expired, because that clock has already started for the period of protection, and if other terms and conditions need to change, like who can share the information with whom. Next slide, I think we're almost done. Expiration of the NDA. So this whole time, you've been exchanging information, you've been managing the requirements and obligations. Now the NDA has expired, and so the period of exchange has sort of ended. Then you just need, the clock starts for the period of protection. So you need to figure out how you're going to manage that information. Are you allowed to continue to use that information? And if so, how? And then you continue until that expiration of period of protection is over. And then typically the NDA will say maybe the obligations have ceased or the use restrictions have ceased, unless it specifically says that you cannot use it. So you really need to go back upon the expiration of the NDA and figure out what you need to do from here, especially if there's a perpetual period of information that you're going to have to figure out how you're going to manage that for forever. And then you'll need to see if there's any obligations of sending the information back to the disclosing party, or do you need to destroy it and send a certificate of destruction. So those are some of the things to think about as the NDA term expires. Next slide. Oh, and that's it. So I think if you all have any questions.
Yes, we have a question here. What are your thoughts when companies don't provide a warranty regarding the accuracy of information they provide, or state that the information is provided as is?
Yes, we have a similar statement. You know, we're an R&D laboratory, so we cannot represent or warrant, you know, a lot of the basic science R&D that we're doing. So we do accept those clauses from other companies because we usually they're, you know, pretty basic early research type things, and you don't know how it's gonna, you know, you can't really represent or warrant how it's gonna work.
Okay, thank you. This could be for Jim or for you. Are there different costs for different levels of misappropriation?
Oh, for 18 USC 1905?
I
Is that
believe so.
related to that? Okay, that I don't know the answer to. I'm sure there's some sort of, you know, I'm guessing if it gets litigated, then the judge would determine what sort of damages, and it probably depends on the severity of the offense. I don't know if Jim wants to add anything.
I don't, oh, there he is.
There he is.
I believe you're muted. Uh-oh. Is your volume down, maybe? I think we'll let him check on that, and we'll come back to him when he's ready there. How long does a typical NDA last?
So a lot of times it depends on the project. I would say it lasts, the term that you're going to be sharing the information is probably 2 to 3 years, can go up to 5 years. It's usually not longer than 5 years because you're usually not going to be exchanging information for that long.
Okay. Let's see. Does Sandia agree to residual clauses in its NDAs?
Yes, we agree to residual clauses, and sometimes we insert those clauses into the NDA as well. I have a colleague that says you can't just have a lobotomy and forget all the information that you learned, you know, from the information you received under an NDA. You can destroy those documents, you can return those documents, but you can't erase what you learned from your mind.
Let's see, if you have, so this might go along with the lobotomy question there. If you have access to confidential equipment or materials, when is it supposed to be returned? So you can't return, obviously, the knowledge, but what equipment then should be returned?
It should state in the NDA. So if we're getting equipment, typically we would do that under some other sort of agreement. Maybe if there's IP involved, a bailment. If there's a biological or chemical material involved, it would be under a materials transfer agreement, which would have NDA clauses. And that should say, 1, if the materials are going to be destroyed, 2, if the materials are going to be returned and when, and 3, what to do if they're inadvertently destroyed and you can't return them. So typically we will take care of that within an NDA or in an MTA, a material transfer agreement. Does that answer that question?
I think so. I think so.
Okay.
What are typical grounds for litigation?
Well, that's a good question. We have not had any litigation at Sandia for under an NDA, related to an NDA, thank goodness, knock on wood. I would think the biggest claim would be breaching the protection use restriction. So you inadvertently shared something, or maybe you inadvertently published a third party's proprietary information and breached the NDA. I would think that would be the most common one, but maybe I mean, there's a whole number of things, but I would think that would be the biggest one. Sharing somebody else's sensitive information when you shouldn't have.
Yeah. Let's see. Jim, I think they're still trying, they're going to see if they can try something else for you. Let's see. Can I amend an existing NDA? So you talked about expiring, but can you amend those?
Yes, depending on the circumstance, sometimes it's easier to amend. I mean, we've certainly amended NDAs when we need to extend the exchange period of the term. Like maybe you had a 1-year term, you thought you were going to be in this relationship and exchange of information for a year. Turns out it's going to be longer. So you can amend the NDA to extend the term of the NDA. Keep in mind, if you're going to do that, do you want to also extend the term of the period of protection? Do you want it to extend past the initial term and go to the new term under the amendment? You could amend the purpose if it's sort of related to the purpose. That would work. You could amend it if one party wants to share it with a government or needs to share it with a government customer, rather than getting explicit written approval. Perhaps you amend the NDA. Yeah, so there's a lot of different situations where you can amend an NDA.
Okay. Jim, can you say something now, I think?
Okay, I'm trying again.
Yay! Okay.
Okay. If a government employee reveals, something that they shouldn't, confidential proprietary information, not confidential again, Samantha was correct. We get that confused with security things. But proprietary information, under the old rules of 18 U.S.C. 1905, the employee basically could go to jail for a year or longer, maybe, depending on the circumstances, and had to be fired. So it was kind of a big deal then.
So the other questions that we asked Samantha, did you have anything that you wanted to add with those as well? How long does a typical NDA last if you have access to confidential equipment?
Our agreements usually follow cooperative research and development agreements, so it's for the term of the CRADA, and so generally it would be after the agreement's done, we would send back the equipment. The equipment wouldn't last past the term of the CRADA. Typically, government rights, I think we would almost always try to return the outside parties' information at the expiration of the agreement. If it was co-developed information, we generally just keep it, and I think that we can protect it for about 5 years. So that's the rules there.
Okay, then to follow up with that, what are the differences then between an NDA and the CRADA? Are they similar? How are they different?
Typically, a CRADA is governed by, cooperative work. I have heard from other labs who have said that they have to have work under the CRADA. My lab doesn't have to have work. We can use a CRADA just for bilateral or even unilateral exchanges of information. As long as both parties kind of have some cooperative interest concerning the information. So the statement of work governs a lot of what we're going to do under a CRADA. And that's, it says, okay, party A is going to be providing this information, party B is going to be providing this other information. Sometimes there is a license of background technology in the CRADA saying, yes, we acknowledge during our cooperative research that this party is going to be using the other party's patents or something. So it is governed pretty much by the statement of work.
Great.
And just a note that at least Sandia is a DOE and NSA lab. We are not allowed to just exchange information under a CRADA. We must have some sort of collaborative work under the CRADA. It's scrutinized much more heavily, the CRADA is. It's only one of 2 ways that Sandia can work with a non-federal entity. So it must go through an extensive approval process. So when we're just exchanging information, we information we use the non-disclosure agreement. So I think different labs must have different requirements.
How long does that process take, the review process? Is it
For a
different?
non-disclosure agreement?
Yeah.
Non-disclosure agreements, we try to turn around. We do a lot of them. We do about 900 a year. So we try to review and get non-disclosure agreements done in the legal review in a day and a half is our goal. A lot of times it depends on the other party and how long their review of the NDA takes, but you can do them relatively quickly. And we try to streamline that process because we do so many of them.
Amy, let me add something here. Well, because we don't usually do NDAs, instead we would prefer CRADAs. Again, if we don't have the authority, that authority has to go somewhere. So typically we have streamlined the CRADA process as much as we can. The real problem is our CRADAs tend to be pretty long documents, and then it requires legal review on the other side, and that's a real holdup for me. Over.
So one last question that I see here, if anybody else has any, go ahead and put them in our question area. But the last one is, if there was already information that was shared, that there's really no retroactive type process, but how do you protect that information, or is that just gone? Is that just public?
Yeah, I mean, you could try to retroactively protect it. You'd have to talk to the other party to see, if they have been protecting it. But you could always retroactively try to put in place an NDA. We don't like it at Sandia because that just introduces risk for information we've already received. But you could try it as long as both parties agree to it.
And is there a CRADA template that is available, or is this just based per instance, I guess?
So DOE has a DOE order that has the CRADA template in it. Those templates are for the DOE labs. I don't know how the other federal agencies handle their CRADA templates.
The Navy has a template that's controlled by the Office of Naval Research. It is fairly comprehensive, and again, because of that, fairly long. My understanding is that a lot of the other, the Air Force and the Army, their templates are much smaller, and also they tend to be done on a lab-by-lab basis instead of being a standard.
Okay. Are there any final comments from the two of you?
I don't think I have any other final comments. Just please read the non-disclosure agreements.
Well, on behalf of the FLC, I would like to thank Samantha and James for this informative discussion. And thank you to all of our attendees for joining today. As a reminder, a recording of the webinar will soon be available to view on the FLC Learning Center on our new FLC website, which launched today. And it will also be available on our YouTube channel, the FLC channel. Please remember to complete the webinar evaluation, which will be sent to you within the week. That'll help us get some feedback and see what we can do, we can change. This will help us to serve all of your needs in the future. And thank you again, and have a great rest of your day. Stay cool if you're in one of those hot areas, and enjoy your day. Thank you so much.
Bye.
Bye, thank you.